So look, there was a lot that came out of this multi-day preliminary hearing in the David case. Not only did a judge officially determine that there was sufficient evidence, sufficient probable cause to support the charges that David faces for this now to go to trial. This is all in connection with the death of 14-year-old Celeste Rivas Hernandez. But we also got a sense of what this trial could look like, the evidence, the defenses. And I got to tell you, there were aspects of the prosecution's case that were surprising. There were aspects that make me wonder whether, as of right now...
First, a preliminary hearing in Los Angeles confirmed probable cause to move toward trial in one of the most brutal allegations in recent memory. Second, 2 chainsaws tested negative for blood, despite them being central to the prosecution's theory of dismemberment. Third, the defense highlighted a gap no one expected. The Uber driver couldn't pinpoint exactly where the alleged victim was dropped off. No surveillance footage showed her entering the house. Fourth, the prosecution's own statement revealed they presented, quote, a significant but small fraction of our evidence, a line that raises immediate questions about what wasn't shown. Fifth, a missing chainsaw, allegedly disposed of in Santa Barbara, is now the subject of competing theories about what happened in that house on that specific night. Between the documented facts and the narrative taking shape in courtrooms and on social media, sits a question worth sitting with. Does the evidence actually support the charges being pursued? Or are we watching a case where the presumption of guilt has outpaced the burden of proof? This is what we know, what we don't, and why the gaps matter. The preliminary hearing lasted days. Prosecutors called witnesses, presented phone records, text exchanges, photos recovered from devices. The core allegation is Starka Singer. David Burke invited a 14-year-old to his home in April 2025, stabbed her, dismembered her remains, and disposed of evidence across multiple counties. What the prosecution did not present, according to their own district attorney Nathan Hawkman, was most of their case. That statement, made on the record, is crucial to understand. A preliminary hearing, legally speaking, requires only probable cause, not proof beyond reasonable doubt. The threshold is lower. The burden is lighter. So when Hawkman stood up and said they're holding back significant evidence, he was being honest about the process. He was also signaling something else. What you saw was not the full picture. The question that follows is automatic. What was omitted? And why does it matter to the defense strategy?
Yeah, so that part's not a big surprise. We finally got to look at what some of the prosecution's evidence is, and there were some surprises there, and there was also a lot of questions I still have. But I guess that's part of the process, and without having those grand jury transcripts open to the public, I think there's going to be some questions.
Yeah, I have a lot of questions about the evidence. I have questions about what kind of evidence they have to support the...
One specific detail emerged as the preliminary hearing concluded. Private investigator Steve Fisher, who has been following this case since early reporting, noticed the district attorney used the phrase recipient witnesses. That's legal terminology for people with direct knowledge of events. Fisher questioned why that phrase appeared in closing remarks when no such witnesses had testified. The implication is clear, worth parsing. Either there are witnesses with information about what happened inside that house who did not take the stand during preliminary proceedings, or there are people who received confessions, admissions, statements from the accused that have not been presented to the court yet. The prosecution, in other words, may know more about the sequence of events than the preliminary hearing revealed. This is not unusual in high-profile cases. It does raise a question about what that missing testimony might show, and whether it would strengthen or complicate the narrative the state is building. The murder weapon has not been recovered. The medical examiner testified that because of the state of decomposition, she could not identify with certainty the exact dimensions or type of blade used. This means, officially, the prosecution does not know what cut Celeste Rivas Hernandez. They don't know if it was a kitchen knife, a blade, a serrated edge, something else entirely. The assumption, widely held, is that it was probably a knife. Assumptions in a courtroom, however, are not evidence. The absence of the murder weapon is not proof of guilt, but it is a forensic gap. It means the prosecution's narrative depends on inference, on what should have happened, rather than on recovered physical evidence that confirms it. 2 chainsaws were found in Burke's home. Both tested negative for blood.
Blood, no murder weapon. We don't have the actual murder weapon. There was a conversation if there's a missing chainsaw, fake blood in the home. So I don't know the idea. All these items were purchased for what, a music shoot? But I thought the defense kind of raised some points there that I wonder is going to be pause for a jury. I give it to you on that charge. What do you think?
Listen, I do agree. I do think there's strong evidence on the mutilation.
The defense raised the immediate question: if these chainsaws were central to the dismemberment, if this is the tool used to cut Celeste's remains into pieces for disposal, why would they be found in the garage, untouched, with no biological evidence on them? The prosecution's response, implicit in their case construction, is that a third chainsaw exists. That Burke purchased a chainsaw, used it, and then disposed of it separately, likely in Santa Barbara. During one of the trips, his Tesla data allegedly places him there. This is worth flagging as a disputed claim. The prosecution contends this happened. The defense contends it didn't. Neither has produced the missing chainsaw. So what we're discussing is a tool that may or may not exist, may or may not be in a remote area of Santa Barbara, may or may not be the actual instrument used. The prosecution is asking a jury to believe in an object that hasn't been found. Blue plastic fragments were reportedly found embedded in Celeste's remains. A blue inflatable pool was discovered in Burke's garage, and that pool allegedly had cuts. The logic follows: the pool is where he cut the body. The plastic fragments match. The connection is clear. Yet this raises a complication the preliminary hearing briefly touched on. The timeline between the alleged murder on April 23rd and the discovery of this evidence spans weeks. A pool with cuts sits in a garage. Chainsaws sit in a garage. A blue Tesla with 11 air fresheners, allegedly used to transport remains, sits in the driveway. If Burke was actively trying to hide what he had done, if he was covering his tracks, it defies logic that he would leave this evidence behind. Accessible, discoverable. Fisher, the private investigator, noted this himself: the stupidity, if you're trying to cover this up. Which raises an alternative frame worth considering, also contested and unproven. What if Burke knew he would be caught and was simply waiting? What if the evidence wasn't left behind by accident, but by resignation? The text messages between Burke and the victim paint a picture of an inappropriate relationship. The alleged photos on his phone show, according to prosecutors, sexual contact between an adult and a minor. The continuous sexual abuse charge in the preliminary hearing seemed the strongest, least contested piece of the prosecution's case. But even this charge carries a complication buried in cross-examination. The defense raised the question, did the victim tell him she was older? Did she lie about her age? The prosecutor responded that it doesn't matter. Even if she misrepresented herself, even if he believed she was older, the law holds him responsible. She was 13 when the relationship began. Under 14 for the alleged sexual contact. His knowledge or belief is irrelevant. This is sound law. It is also, from a jury perspective, a harder sell than it appears. A jury might understand, intellectually, that age of consent doesn't bend on belief. But in the privacy of deliberation, in the space where emotions meet doubt, a jury might also think he thought she was older. The prosecution knows this, which is why they built the continuous sexual abuse charge so carefully. It doesn't require proving murder. It doesn't require proving he lured her or planned anything. It requires only proving sexual contact with a minor he knew was a minor. That charge survives preliminary hearing almost without challenge.
And the strongest one is continuous sexual abuse of a child under 14. When you was presented these alleged graphic sexual photos reportedly found on David's phone, seemingly of him and Celeste allegedly engaged in sex acts, the text seemingly about abortion, to me, that feels like a slam dunk for the prosecution. I don't know if you agree, because it came up yesterday, this idea about what did Celeste tell him about her age, but you had Beth Silverman who said that's not a defense. Even if she lied about her age or didn't know her age, it doesn't absolve him of liability. So would you agree that after what you saw in these past few days, that seems to be the toughest charge for the defense?
Yeah, I mean, I don't see any way of overcoming that. Listen, you have the West Hollywood sheriff's deputy who told him she was a 13-year-old runaway. Listen, he knew where she went to school. These phones that were passed to her, these are through classmates at that school. And so I think that's something, and I think they even kind of admitted that, because in the closing, from what I understand, I wasn't in there yesterday, but they said David was in love with her. And so right there, I mean, they're essentially admitting it.
The first-degree murder charge, however, is where friction emerges. The prosecution alleges premeditation, lying in wait, deliberation. The evidence they presented suggests something different, or at least something less clearly proven. Burke was playing video games when Celeste allegedly arrived. He texted her, "The door is open." These do not read as the actions of someone who had been rehearsing murder, preparing mentally, working through the details of what he would do when she arrived.
I question, because David comes out, he's playing virtual reality video games while she's on her way there. He's like, "Hey, I left the door open." He doesn't seem like a guy who's like waiting, rehearsing, getting maths down or anything like that.
The defense seized on this. They highlighted that Celeste, according to text exchanges, allegedly threatened him, allegedly invited herself over, allegedly initiated contact. They raised the possibility of self-defense.
Mental health. But I mean, are they setting up an argument? You don't know what actually happened in that house. You don't know if he acted in self-defense. You don't know if she hurt herself. That's where I thought the defense was going, particularly.
They suggested that what happened in that house was not premeditated, but spontaneous, a situation that escalated. An act committed in the heat of a moment, not the cold calculation of someone who bought pool liners and chainsaws days in advance. The question of premeditation separates first-degree murder from second-degree murder in California. It separates death penalty eligibility from life without parole. It matters immensely. The most contested charge, the one the defense focused on, was premeditation and first-degree murder.
So first, let me be very clear. I think David did this. 100%. I believe that. I really do. I've been very vocal about that. However, there is a difference between him doing this and possibly being overcharged, to a point where can they prove that? I think that, let's talk about the special circumstances first. I think the luring, I don't see it myself. I think that she was willing to come to the house. I didn't see any desperate attempt by him to get her there at that moment, or I don't think he conned her, or, by saying, making.
The special circumstances allegations include killing to prevent disclosure. The prosecution contends Celeste threatened to expose the relationship, that Burke killed her to silence her. The evidence presented at preliminary hearing was a text where she allegedly said she could ruin him, or words to that effect. She did not. According to testimony, explicitly threatened to go to law enforcement. She did not say she would call the police. The language is ambiguous. She could ruin, you could mean many things, could be interpreted many ways. Is that sufficient evidence to prove killing for the purpose of preventing disclosure? That is a contested claim the defense will challenge. It is also something the jury will ultimately decide. But at preliminary hearing, the foundation felt thin. This is not a judgment on guilt or innocence. It is an observation about the evidentiary threshold.
And in the first day testimony, we have this financial witness, the financial advisor, who had to admit that he lied during his grand jury testimony and said that he originally said he never asked Rob Morgenrath what happened because he didn't want to know. But Beth was forced to get him on the record to clarify that. And he actually clarified it and said, I actually did ask Rob, and he did tell me what happened, yes. And then she moved on. But the next part was how they immediately started to raise $2 million in bond money before Celeste was even identified that it was Celeste.
The Santa Barbara trips emerge as another point of tension between the narrative the prosecution is building and the gaps in the evidence. Burkett's Tesla allegedly placed him in Santa Barbara on April 23rd, the night of the alleged murder, and on subsequent dates. The passport of Celeste Rivas Hernandez was found on a road in Santa Barbara. The prosecution's story is clear. Burke drove to Santa Barbara to dispose of evidence, perhaps to dispose of the body or parts of it.
Yeah, I think that chainsaw might be in Santa Barbara.
Really?
I think on the second or third trip, I think he could have been, getting, because if you look at that second trip, they're contending that it happened around May 5th, around Cinco de Mayo. And May 8th, I think he took another trip up there. And that makes me wonder if it was to dispose of things near that lake or something. But, I don't know that for sure. I just think that could be a reason that the ID was ultimately found up there as well.
The defense, through private investigator Fisher, suggests an alternative theory, unproven but worth noting. Fisher questions whether Celeste was even in the car on those trips. He notes that if she was killed on April 23rd and dismembered, the subsequent trips on May 5th and May 8th would be for disposal only. But those disposal trips don't, in Fisher's view, necessarily prove she was in the vehicle on the first trip, the April 23rd trip, the night of the alleged murder. There is a logical distance here between knowing Burke went to Santa Barbara and knowing Celeste's body went with him. The prosecution will likely argue that the Tesla data, combined with the timing, combined with the discovery of her passport there, proves it. The defense will argue that proves only that Burke went to Santa Barbara, not what he transported or why. The financial motive allegation offers another angle of complicated evidence. The prosecution suggested Burke killed to gain financially or to prevent financial damage. But the defense raised a question that prosecutors struggled to answer. Why would Burke, who had money, who had options, kill a 13, Year old to avoid financial consequences.
Says, I could ruin you or not, but she doesn't say anything specifically about going to law enforcement or anything. It makes it sound like it's more like she'll just kind of let word out. We'll see. I know that all those charges have been held over, but when he's formally arraigned, we'll see. Maybe they're not all there when he's formally arraigned now. So I don't know. It'll be.
The media coverage of this case has moved faster than the evidence itself. Social media has convicted David Burke in the court of public opinion. The narrative is set a predator who killed to cover his crimes. But the preliminary hearing, for those who followed it closely, told a story both darker and more complicated. It told a story where some evidence is strong, some is circumstantial, some doesn't exist yet. It told a story where the prosecution has more evidence than they showed, and the defense has raised questions the prosecution hasn't fully answered. This is how high-profile cases work. The media often settles on a narrative before the legal process catches up to it. The narrative then shapes how evidence is received, how gaps are interpreted. If you believe Burke is a predator, and you see a blue pool in his garage, you interpret it as a murder scene. If you're skeptical of that narrative, you wonder why he didn't dispose of it. If you trust the state's case, you assume the missing chainsaw is in Santa Barbara waiting to be found. If you don't, you wonder if it ever existed at all. The preliminary hearing showed us that reasonable people, looking at the same evidence, can come to different conclusions about what it means. One theory that has circulated, worth examining and flagging as unproven, is that Burke did not act alone. The reference to recipient witnesses, the mention of people who knew what happened, the revelation that Burke allegedly confessed to someone. All of this suggests that at least one other person had knowledge of events. But the preliminary hearing did not establish accomplice liability. No co-defendant has been charged. No second person has been arrested. The prosecution may believe someone else was involved. They may have evidence of it. But they presented a case against Burke, singular, as though he acted alone. This asymmetry, this gap between what they know and what they charged, is worth noting. The case moves toward trial now. The next formal step is an arraignment where charges will be read and Burke will enter a plea. Between now and trial, months or years may pass. The prosecution will continue gathering evidence. They will present the additional evidence they alluded to at preliminary hearing. The defense will prepare, will investigate, will challenge the state's theory. The judge will rule on what evidence is admissible, what testimony is allowed, what narrative the jury will ultimately hear. This is the process. It is slow. It is intentional. It is designed to separate emotional conviction from legal proof.
This is for his arraignment. This is where the formal charges will be read. Attorney Patrick Steinfeld, who represents Celeste's family, said that they are relieved that this is moving forward. Now, to be clear, these are all.
What remains worth sitting with is this. The strongest evidence at preliminary hearing was not about murder. It was about sexual abuse. The most contested charge, the one the defense focused on, was premeditation and first-degree murder. The evidence the prosecution presented was incomplete by their own admission. The physical evidence, in some cases, seems to raise as many questions as it answers. The timeline is complex. The motive is challenged. The weapon is missing. The victim's manner of death is clear, but the context of that death, the sequence of events, the degree to which Burke planned it versus reacted to it, remains genuinely contested. A jury will have to weigh all of this. a jury will have to decide whether the evidence establishes guilt beyond a reasonable doubt. Based on what was presented at preliminary hearing, based on the gaps and questions Fisher and others have raised, it is possible to believe Burke committed these acts and still hold questions about whether first-degree murder with death penalty eligibility is the charge the evidence truly supports. This is not a statement on his guilt or innocence. It is an observation about the distance between what prosecutors believe they can prove and what they actually presented. The investigation continues. More evidence may emerge. More witnesses may testify. The narrative may solidify or it may shift again. What matters now is that we follow closely. We examine the evidence as it appears. We flag contested claims. We resist the urge to settle on a conclusion before the legal process concludes. That is what a case like this demands from people paying attention. That is what separates documented fact from myth.